Hello and welcome. We resume with the question of what is the basis for legal sovereignty? In the Cambridge Law Journal 1955, William Wade, now Professor Sir QC, stated, "Sovereign legislation depends for its authority on what Salmond called an ultimate legal principle. That is, a political fact for which no purely legal explanation can be given. If no statute can establish that the courts obey the UK Parliament, similarly no statute can alter or abolish that rule. It is above and beyond the reach of statute because it is itself the source of the authority of statute." End quote. In other words, were the Parliament the source of statutes, to issue a statute that said the courts had to obey it, rather than vice versa, as is actually the case, from whence would Parliament derive that authority? Such an act would place Parliament in a position of supremacy, whereas the lawful position has always been that the courts enforce the law, but the people decide what it is, with everyone, including the monarch, the Parliament, even the courts, subject to the law, as decided by the people in courts de jure. That is the only legitimate source of sovereign legal authority. The relationship between Parliament, sovereign legal authority, and the courts of law in the United Kingdom is thus unalterable. The Magna Carta Society found it surprising that the alleged supremacy of the European Court of Justice had not been tested up until 1999 in the courts already. If Wade was correct, they argued, then UK courts were supreme in this, the UK's jurisdiction. An attempt had been made by Ross McWhirter of the Freedom Association to bring this to court in 1972. He invoked the Bill of Rights to show that the government did not have the power to give away the rights and liberties of the people. He was mysteriously assassinated before the matter was decided. His brother Norris made a similar attempt to challenge the legality of the Maastricht Treaty in 1993. Summonses were issued against the then Foreign Secretary for treason. The Attorney General used a purported power to take over the case, then drop it as, quote, "not in the public interest," unquote. Yet the Bill of Rights, as we saw in the last video, prohibits, quote, "suspending laws or the operation of laws," end quote. His action was against natural justice because he was, of course, sitting in judgment in his own cause. It is apparent from such goings-on that there were some highly questionable motivations afoot. Various statements emanating from Parliament and from ministers or high-ranking officials over the years under discussion here cannot be claimed to pass what Australians would call the pub test, a phrase used to indicate that if a question were to be raised in any public bar, the answer would be obvious to all the patrons. Examples the Magna Carta Society quotes are, "The House as a whole may therefore be reassured that there is no question of this bill, the European Communities Bill 1972, making 1,000 years of British law subservient to the Code Napoleon." Geoffrey Rippon, Chancellor of the Duchy of Lancaster. Hansard, the 15th of February 1972, page 270. Another, "Our sovereignty cannot be bartered away by the Solicitor General or even by the Prime Minister, because it is not theirs to give. I speak not only of the sovereignty of this House, but also of the higher sovereignty of the British people." That was from Alfred Morris, MP, Hansard, the 17th of February 1972, pages 727 to 28. Further, there is no reason to think that the impact of community law would weaken or destroy any of the basic rights and liberties of any individuals under the law in the United Kingdom. That was from the Lord High Chancellor Command Paper 3301 in 1967. Yet again, no question of any erosion of essential national sovereignty. That was from the White Paper on joining the Common Market, the Heath Government, July 1971. In the 1975 referendum in support of the Yes campaign, Roy Jenkins was equally misleading. He said the position of the Queen is not affected. English common law is not affected. These comments are now seen to be so misleading as to be basically criminal in intent. Yet, as the Magna Carta Society points out, if we give them the benefit of the doubt and ascribe them to be true, then at least the 1971 White Paper and Roy Jenkins' 1975 remarks strongly support the case of the Society's contention that all European legislation in the UK is unconstitutional and therefore null and void. The Society notes a strangely ambiguous statement in the judgment of the Witham case of 1997. Quote, "The common law does not generally speak in the language of constitutional rights, for the good reason that, in the absence of a sovereign text, a written constitution which is logically and legally prior to the power of the legislature, executive and judiciary alike, there is on the face of it no hierarchy of rights such that any one of them is more entrenched by law than any other, at a time when common law continues to accord a legislative ascendancy to Parliament." End quote. Try listening to or reading that several times to see if any discernible meaning becomes any clearer. The Magna Carta Society observes that it brings us back to the question of respect for the actual meaning of words. It's as though the Alice in Wonderland statement, "Words mean what I want them to mean," is the first article of faith of the bureaucratic catechism. Government pronouncements have come to resemble an unstable amalgam of the verbose monologues of Sir Humphrey Appleby and the convoluted logic of the officials in a Kafka novel, through which we currently wade as though through a moat of treacle. The Society concludes, though, that if the words in the Witham judgment have any meaning at all, it's that of overwhelming support for their case, and to be hoped that some of those in or close to the executive, the legislature, or the judiciary will find the force of the arguments and the courage to lend support. In the meantime, the Magna Carta Society returns to its consideration of the role of the monarch regarding the Constitution. They argue that the monarch, as the sole repository of sovereign power, is the court of last resort to which subjects may appeal in seeking redress against renegade politicians. In fact, further than that, it is the specific duty of the monarch as laid down in Magna Carta. The coronation oath already referenced is a lifelong contract between the monarch and the people, or the nation. It is not a contract between the sovereign and the parliament, but between the sovereign and each individual. Thus, it cannot be broken by a vote in Parliament, but only by the sovereign or the individual. And like any other contract, if it is breached by one party, or it is believed that the terms may be at risk, the other has the right to call the defaulter to account. The situation today is the same as it has been for over 1,000 years. Namely, if the subject believes their rights and liberties are at risk, they may appeal to the sovereign to protect them. Likewise, the sovereign may call individuals to arms to protect the realm. The Magna Carta Society points to two recent examples of this contract in operation, and of special emphasis is the fact that they come from the two sides of the covenant. In 1975, the Governor-General of Australia, acting on behalf of the Queen, dismissed the Australian Parliament and called new elections when the government attempted to pass legislation which was held to infringe the rights of all Australians. Despite the outrage of government supporters, who erroneously held the view that the elected Parliament was supreme in defiance of the Constitution, which provides checks and balances against the excesses of either the sovereign or the legislature, the subjects overwhelmingly upheld the Crown's actions and ratified the dismissal in a landslide result. The other example was in 1982, when the subjects of the Falkland Islands were afflicted by an invasion of war. The Queen summoned a military force to defend their rights, which was successfully done. Not only do these examples illustrate the status and strength of the monarchy and indicate that it exists to protect the rights and freedoms of the subjects, but they also demonstrate most emphatically that even in a modern context, the Magna Carta and the Declaration of Rights are alive and well. The sovereign is thus the ultimate protector of the nation and the rights of the individual, and these responsibilities are the sovereign's alone. The Magna Carta Society cites a constitutional commentator, Allott, in support of this interpretation. Quote, "For Parliament to develop or improve on a fundamental right is one thing, but to enact legislation which expressly removes an already existing fundamental right, and to have that enactment blindly upheld by a court, is quite another. If there is one thread which runs through the whole turbulent history of British constitutional development, it is the belief that we, Parliament and the courts, are the servants of fundamental constitutional rules, which were there before us and will be there after we are gone." End quote. The Society warns that these rights and protections, established over centuries, these common laws, rights, freedoms and customs, are being ever more rapidly demolished. They use the metaphor of a team of statutory bulldozers. They point out that long ago, Magna Carta dealt with the problem of a monarch acting above the law. Later, the Declaration of Rights confirmed the estates of the realm and their relationship to each other. If imperfectly, as we have already seen, see videos 28 and 29. Flaws inherent in the Declaration of Rights included Parliament attempting to arrogate to itself a position of supremacy, and also the unconstitutional assertion that the monarch had no right to deny royal assent. But it did purport to provide a series of checks and balances nonetheless. Points such as those just noted are not the purpose of this talk. Time limitations prevent an intricate analysis of every point. The aim here is to simply present the basis of the Magna Carta Society's submission. The same observation can be made about the Queen acting upon the 1975 dismissal of the Whitlam government, despite completely overlooking the far more treasonous act of that government selling the Commonwealth of Australia as a corporation to the US Securities and Exchange Commission in 1973 and creating the fictitious office of Queen of Australia. These are issues for discussion in other talks. The Society laments that at the end of the 20th century there existed, quote, "a House of Commons acting above the law, plainly contemptuous of the remaining powers of the Queen and the House of Lords," end quote. That this overwhelming concentration of power in the hands of the executive, particularly one with a huge parliamentary majority, constitutes a serious threat of what Lord Hailsham once called an elective dictatorship, caused extreme concern amongst the members of the Magna Carta Society and tens of thousands of others. They decided that it was high time, indeed overdue, that the principles and rights enshrined in Magna Carta and the Declaration of Rights be put once again to the test. We will return to examine their reasoning and actions concerning this move next time. Thank you for watching.